right, here to talk to us about the state of affirmative action before the U.S. Supreme Court is Godfrey Dillard, a prominent civil rights lawyer, University of Michigan trained lawyer who also represented students in the landmark University of Michigan case before the Supreme Court. Godfrey, thank you so much for being here. In the U of M case, if we come back, along the lines, the court also affirmed, indicating that diversity is a compelling interest.
Well, that's the issue in this case.
Right.
And I think that they're going to rule that it's not a compelling state interest anymore. And I think what causes that is this is a unique case. It's brought by Asians. Another racial minority is claiming that the admission program itself is discriminating against them as well. So I think what you see in the conservatives are now saying we've gone too far. Now even the program that's set up to promote racial discrimination is in itself discriminating against another racially identifiable group, and therefore the court is going to say the state really hasn't made a compelling reason to continue it.
But do you think that the case brought on on behalf of Asian students and white students, does it have any merit here? I mean, does it have any merit? Does
it have merit?
Yeah.
Well, it's making the long-standing arguments that have always been made in race-conscious admission circles. It's claiming that the state cannot meet its burden.
Yeah.
It's claiming that there is not any less drastic way of doing this. And I just think that they've made the decision that we got enough votes and the votes is going to carry the day. Listen, this court has just ruled that Roe went down.
Yeah,
I don't think there's any possibility that
affirmative
action is going to survive. For me, the real question is Clarence Thomas going to write the majority opinion.
You think he's going to write the majority opinion?
I mean, to me, that's the real issue. Is as I said, they're going to argue that they haven't met the compelling state interest anymore because we can't just keep doing it on and on. But it's going to be interesting with Clarence, the oldest conservative on the bench, older than Roberts.
Right.
He's always been against affirmative action, so it's going to be interesting whether he writes it or
whether he puts the nail in the final nail
in
the coffin.
It's set up. It seems almost like a play, but in a lot of ways it's set up for him to do it. It's going to be interesting.
But I think also the larger issue here is that the placement, the opportunity for black students to have in higher ed, to have opportunity and compete in educational institutions.
That's true, but the bottom line, they haven't been able to increase the numbers, Bankole.
Yes.
The numbers have stayed at this 2-3% in terms of black students, and I think that as a consequence of that, when they now have another minority group saying that we are being discriminated against, I mean, it really disrupts everything.
Yes, yeah.
And that's what makes this case really unique.
It's almost like a house divided cannot stand.
That's correct. It's what makes the case really unique is that they've now convinced a small number of Asian Americans, students for fair admissions in higher education, to come forward as plaintiffs, because the vast majority of the Asian, I'm not speaking for the Asian community, but the vast majority of the traditional organizations did not support this effort. They still see that diversity is very important. We need it in education. But the interesting thing about the case also is that it goes all the way back to Brown versus Board of Education.
Yeah.
It deals with equal protection. It deals with Brown overruling Plessy v. Ferguson, separate but equal.
Right.
So you've got this equal opportunity issue, which you just talked about, playing out in one sense, and then on the second side, we have this issue in education where education has become a zero-sum kind of game. Letting somebody in is viewed as taking something away from somebody else. And unfortunately, I think we've got to the point now where they're going to say that the individual assessment is going to be trumped by the numbers. The bottom line, the only way we're going to justify this is that the highest score gets you in. You know, in other words, the highest grade point standardized test score gets you in. And of course, under that standard, historically, minority communities have not been able to get it, except for this minority community, the Asians, who score on a higher average than the whites. They're percentage-wise, they're the largest, moving to be the largest group, which is amazing. You know, to see that that's happening, but it's much like women. You know, women have historically
but is there advancement going even against the crux of their lawsuit itself?
Say that again?
Is there advancement, what you're saying in terms of, you know, they're among the largest minority that are moving forward. Does that advancement go against their own lawsuit?
No, they're claiming racial discrimination.
Yeah.
The Asians are claiming, that's what's in, it's not a classic affirmative action case. Yeah. Typically, what you're saying in a classic affirmative action case is the white student is being discriminated against.
Exactly, white versus black.
Right, yeah, that's what black and white, but in this case, you know it's not that. It's that the Asian is being discriminated against, and that's what I think is the tipping point.
Yeah.
With this conservative Supreme Court, they can now say you've gone too far. You know,
so this is the perfect model that they need.
Yeah, if this is the model that you need, but now you're discriminating against another minority group. Now, don't get me wrong, I'm not in favor of that. I think there's a counter argument to that. But that's what they're pushing. And I think with the 6-3 majority now on the court, it's going to come through. The only question in my mind is whether Clarence is going to write the majority opinion.
Yeah, the majority opinion aside, obviously we're also going to see who's going to write the dissenting opinion. I mean, does that fall?
Well, that's Sotomayor.
Sotomayor, not Ketanji Brown Jackson.
No, she's not.
Because she's new in the court.
She's new. No. But you know, this is the most diverse court in history now.
Yes, it is.
Dealing with this particular case, which also is fascinating. You know, you got 4 women on the bench, and then you got 2. You know, you got a black male and Clarence Thompson and Ms. Jackson on the female side. So you got the most diverse Supreme Court, but it is still, you know, it's politics that's trumping the race. You got a conservative, overwhelming majority now, and the problem for me as a lawyer is, it's another 30 years. You have to understand these folks are going to be on that bench for another 20, 30 years, and if you've got this dominant, a lot of the precedents that we've seen in the past, I think, in civil rights and some other, in labor, and a lot of labor area, guns, all of these cultural issues are going to, the precedents that existed before, I think they're going to start falling. Wade is just the first one of them. And now you're going to see affirmative action. And next week it'll be something, next year it'll be something else.
If this particular filing case goes, you trace it directly to Brown, it stands to chip away from the gains of the civil rights movement.
Absolutely it does. The equal protection had the problem with equal protection, and it came out in Brown, it has 2 aspects. It has the idea that all discrimination is bad, is wrong. The discrimination of Jim Crow period was wrong. And then on another side, it has an opportunity to increase equality of opportunity by saying education is the way in which we can equalize things, and such that they began to say that, you can't have these racially discriminatory school districts anymore. You got to allow black. So it has an equal opportunity aspect to it, but it also has a blanket argument against racial discrimination. And that's kind of where the case is. And if you kind of look at it real closely, you'll see here you've got the Asians saying no discrimination, period. That kind of, you can argue that under Brown. And then at the other side, you got to say, well, we got to have a more diverse student body. We're going to a more diverse world. We got to have this. And so we can't have all the whites having all these leadership roles in the future. We have to be able to grow. So you can see Brown in both situations. But unfortunately, education has become a zero-sum game Bankole.
Yeah.
You know, it's, you know, they want to use the score, this technical analytical score, as a decider of merit, which I've always been against. I always felt more that what I believe in the Powell doctrine is that the individual assessment is what's always happened in education. You know, it always was about, it never was about every student gets an A, becomes, you know, the astronaut. No, a lot of times it's the C student that becomes the astronaut. But the C student learns from the A student, B student, and so you got all this diversity going on. So it's unfortunate. I just don't see much hope of us surviving it. I don't think I ever would have thought that, but you know, once Trump put added the 3 conservatives, and you know, and they're hey, they took down Roe.
Right. Yeah. But I'm looking at also the larger implication. Is there any larger implications regarding this case as it relates to affirmative action programs that are not targeted for universities or colleges, but just government affirmative action programs in, you know,
well, they haven't
in public institutions.
I think ultimately they're in danger. If you're talking about these future economic programs that the federal government is putting in,
that came from Lyndon Johnson, the executive order 12.
Well, you know, that's going to promote diversity not only in schools but in government contracts. All of those, I think, are in jeopardy now with this ruling. Because I think, as I said, I think the court is so conservative now, and they're entrenched, that they're going to move the cultural wheel back a little bit. They think it has gone too far. I see them going after the marriage issue that they recently signed. I see that, if they, you know, I can see them going after that. You know, so we're in a very, you know, conservative situation right now. You know, I think on the law side, we have to try to find new approaches, Bankole.
That's what I want to know. I mean, what's the recourse here? I mean, what is, you know,
I think
black lawyers?
Yeah, I think, you know, the traditional equal, you know, 14th Amendment equal opportunity approach is not working anymore because it's not black and white anymore. It's a much more diverse world. So we got to come up with other strategies to prove discrimination other than just counting the numbers, saying you got 10 blacks in there and you got 100 whites in here, or you got 30 Asians, you got 60 here. We got to, we're losing that battle, particularly with this court. You know, I think I want to go back to what we learned from Thurgood and then when they did the original Brown. They sought out the most favorable scientific analytical approach to prove their case. You know, you can call it simplistic, but the idea of the black dial and the white dial was a very sophisticated sociological theoretical argument at the time. And there was no guarantee it was going to carry the day at the time. I think now we need to get into analytics a little bit more. Implicit bias. I think we need to explore this implicit bias situation where we can show from a technical point of view that they could have this particular viewpoint, even though it's on the conscious level, they don't quite recognize it. So I think, you know, those are the that's one approach that I think we need to do, is implicit bias.
Sounds like Harvard and University of North Carolina should have you arguing their case before the Supreme Court. You've already done it with the University of Michigan. Thank you so much for being here.
Thank you, Bankole.
All right, Godfrey Dillard, the eminent civil rights lawyer, talking to us here on Sunday Nation about the state of the affirmative action case before the nation's highest court. We'll be right back after this break.